Welcome to the Legalpreneur Podcast. I'm your host, Andrea Sager, founder and CEO of Legalpreneur Inc. As a serial entrepreneur and someone that works exclusively with small business owners legally protecting their business, I'm dedicated to covering common legal issues faced by business owners, providing you with the business knowledge you need to catapult your business's growth and showing you just how some of the world's most elite entrepreneurs have handled these legal and business issues themselves. In true attorney fashion, the information in this episode is not legal advice. This is for informational purposes only, and you should always consult with your attorney before implementing any of the information in the show. Hey there, welcome back to another episode of the Legalpreneur Podcast. So last Monday, we talked about t-shirt designs being registered as trademarks, and I mentioned briefly about the Principal Registry and the Supplemental Registry. So today I'm going to chat about the differences and what they really mean. But before we get into that, you guys, we're having our next free legal training of the year, and this is 5 steps to legally protecting your business. This is our biggest webinar that we do. This is by far the most popular, and we do have limited seats. Last time, I think people couldn't get in the room because there were so many people signed up. So make sure you hurry up and sign up in order to reserve your seat and show up live. You got to get there early to reserve your seat. Last time, I think people just got there late and they couldn't get in the room because it was full. So freelegaltraining.com. You can also click the link in the show notes, but sign up. Seriously, you don't want to miss this. We literally teach everything that's here and it's there, blah, blah. We put it all in one place in this one training. So go check it out, freelegaltraining.com, and I will see you on April 6th or the 7th. We have 2 different times to choose from. It's the same training both days. We just provide 2 different times. That way you can choose which works best for you. We are so pumped for this. We were debating on whether to have it in April or May, but we were like, no, let's just go ahead and have it now. And we'll probably have it again in May or June, but right now, sign up for the training in April. Okay, so today's episode, principal versus supplemental. Last week, we talked about how some trademarks may not actually qualify for the principal registry. And the thing is, most people don't even know there's 2 different registries, principal and supplemental. Both have benefits. The supplemental has some downside, but if you don't qualify for the principal registry, supplemental is better than nothing. So the biggest thing is that if you qualify for supplemental, take it. If you don't qualify for principal, just take the supplemental, because that's what you need to get started protecting your trademarks. And those that don't qualify for the principal registry, typically it's because they are descriptive. And there's different reasons for being descriptive. I don't want to go through all of them now, but like I talked about last week, a t-shirt design being ornamental, which means just for decoration. Ornamental is typically descriptive. Also, if you have a city or state, typically a city or state, things that you can't own individually, those speak to being supplemental and descriptive. If it is descriptive, describing the thing that it is protecting, then it's probably descriptive and needs to be on the supplemental registry. However, if you've been using the mark for 5 years, so you've been using the name for 5 years, then you may be able to still be on the principal registry. There's a lot of details here, so I don't want to go into too many rabbit holes, but just know that if you've been using the name for 5 years, let's say you file the application, the trademark examining attorney is like, hey, you got to be on the supplemental. But if you've actually been using it for 5 years, you can let them know that you have acquired distinctiveness. It's a industry term, but basically the trademark office assumes that after you've been using it for 5 years, then the public has actually made that name be distinctive with your brand, even though it is descriptive. So a couple of differences for the principal versus supplemental registry. The biggest differences come when there are issues with the trademark. So, and when I mean issues, like if you find another brand that's potentially infringing on your trademark, that's really when the issues arise. Because if no matter if you're on the principal registry or the supplemental registry, you can still use the R circle symbol. It'll still cause another similar trademark to be denied if they do file a trademark application. So, like I said, even if you only qualify for supplemental, take it. But more differences. So, let's say there you have your descriptive trademark, it's on the supplemental registry, and there's another name out there, whether it's the same or something similar, that is causing confusion. If there is a lawsuit for trademark infringement, if you're on the supplemental registry, you don't have presumption of validity, which is huge. So presumption of validity basically means if you are on the principal registry and there's a trademark lawsuit, the other party has to prove you don't have trademark rights. So they're assuming you already have the trademark rights because you're on the principal registry. If you're on the supplemental registry, you still have to prove that you do have trademark rights. The court's not assuming that you already have trademark rights, even though you do have a trademark registration because it's on the supplemental registry. Now, that's the biggest main difference. So just keep in mind, like the biggest difference is when there's a lawsuit, who has the burden of proving, is there a trademark or is there not? If you're on the principal registry, they have to prove you don't have trademark rights. If you're on the supplemental registry, you have to prove you still do have trademark rights. And that's where showing, hey, we do have trademark rights. We've been treating it like a trademark. We have this registry, even though it's on the supplemental registry, we're still protecting it as if it is a real trademark, which, I mean, arguably it is. So the other big difference is being able to make it incontestable. So incontestable. So after you've been registered for 5 to 6 years, you have to renew the trademark, and you also file an affidavit basically saying, hey, this cannot be contested for certain reasons. So, and again, I don't want to go down these rabbit holes, but, and I don't want to explain those reasons, but basically before that 5 and 6 years, somebody can file a trademark cancellation for certain reasons. Once you file that section, it's called a Section 15 affidavit. When you renew between 5 and 6 years, you basically are telling the trademark office, that's signaling to the trademark office, hey, they've been using it this whole time, and that means those certain reasons are no longer applicable. So basically, it becomes a stronger trademark. That's when you're on the principal. When you're on supplemental, you actually cannot file that affidavit. However, like I said, if you've been using it for 5 years, you can then reapply and get on the principal registry. So essentially, you just have to keep using it you have to be registered for another 5 to 6 years. Then you can file the renewal with the Section 15 affidavit at that point. Another big one, if you manufacture items overseas, you can actually submit your registration to customs, and customs will help to prevent importing counterfeits when you're on the principal registry. However, if you're on the supplemental registry, you cannot do that. Another big one is intent to use. So when you file a trademark, if you're not already using it, you can file an intent to use application. Basically means you have a good faith intention to eventually use that trademark within a certain amount of time. If you're on the principal, you can file intent to use. If it's descriptive and you have to be on the supplemental, you actually can't file an intent to use application. So those are like the big differences, but just know that there are still benefits to being on supplemental. Like I said, number one, you can use the R circle symbol. That's a pretty symbol everybody wants to know. Number two, if a third party files an application that's the same or similar, they'll still be denied. And then you can still file in federal court instead of state court, which is definitely a benefit because state court, they just don't really know much about trademarks. So trust me, you want to be in federal court. And then you can apply to be on the principal after 5 years, after you've been using it for 5 years. Now, the biggest thing I want to say about supplemental, so if you're like, oh, I do have descriptive marks, it's like, is it worth it? Absolutely, it's worth it. And the biggest thing to know, like, most people don't know there's a difference between principal and supplemental. Like, you probably didn't know until I told you. And now you're probably confused as hell, but you know there's a difference. And the thing is, like, if you show somebody the registration, they don't know there's a difference unless they have a trademark attorney. Like, other attorneys don't even know that. So if you were to show somebody your trademark registration, unless they were a trademark attorney or very, very familiar with trademarks, they wouldn't know. So if you want to reach out to somebody on your own without hiring an attorney to say, hey, you're using my trademark, please stop using it, you can still show them in the registration, and they're not going to be like, no, I'm not going to stop using it. You're on supplemental. They're going to be like, oh shit, this person has registration. Like, I'm infringing on their trademark. Like, I'm going to stop using it. Okay. That's the down and dirty of principal versus supplemental. I hope this didn't confuse you too much. Just know, even if your mark is descriptive, the name you want to apply for is descriptive, you can still get rights. They just may not be the strong principal rights initially, but you can reapply and get on the principal. So you always want to make sure you're getting as much protection as possible. Okay. That's my little spiel. Go sign up for the 5 steps to legally protecting your business webinar, happening April 6th and 7th. And I'll see you in a couple days. Here at Legalpreneur, we're committed to providing a supportive legal community for all business owners. I know how scary the legal stuff can be. If you found this information helpful, I would be so grateful if you could share it with a fellow business owner. And quite frankly, it doesn't cost anything to rate, review, or subscribe to the show. Your support helps me reach more listeners, which allows me to support more business owners in their entrepreneurial journey. Have any questions or comments about the show? Feel free to drop me a line on Instagram. I promise I read all of the messages and comments. And if you want to be a guest on the show or know someone that would make a great guest, simply fill out our application form and a team member will reach out if we think it's a good fit. I'll see you in the next episode.